thank you for joining us for this case law update. I'm Rich Offord and I'm a Senior Associate in the Commercial IP and Technology Department here at Travers Smith. Today I wanted to talk briefly about a recent case that has examined the importance of worked examples when construing commercial contracts. I'll briefly run through the facts of the relevant case and then we'll discuss some practice points to keep in mind when it comes to using worked examples in contracts. So, the case in question is Altera Voyageur versus Premier Oil, and it was heard remotely in the High Court in July of this year. Basic facts are as follows. Premier Oil is an oil exploration company with interests in the North Sea. Altera Voyageur is a vessel charter company that charters oil and storage vessels. Premier Oil hired a vessel from Altera, and a dispute arose about the level of hire fees that were due. The contract between them relating to the charter of the vessel contained a hire fee adjustment mechanism that was based on the performance of the vessel. If the production and processing systems on board the vessel operated above a certain level, the hire fee could be increased, and similarly, if the systems operated below a certain level, the hire fee could be adjusted downwards. The front end of the contract referred to an appendix which set out the actual formula and method for calculating the adjustment. Now, I'm not going to go into too much detail on the actual formula itself, as it's nightmarishly complicated, but essentially, it sought to measure performance of two key systems against the target availability percentage of 95%. The narrative wording of the formula was then followed by two worked examples. The dispute centered on the fact that the worked examples contained two extra steps that were not included in the narrative wording of the formula. When applied, these steps had the effect of reducing the point at which the fees could be increased to 90%, rather than the target availability percentage, which was clearly stated to be 95%. In this case, availability was above 90%, but below 95%, and accordingly, Altera was seeking to claim a higher fee. Premier argued that the narrative formula should take precedence in this instance, and that the worked examples could not have reflected the parties' intentions. Firstly, because they contained extra steps that went beyond the narrative wording, but also because it could not make commercial sense to have a target availability of 95%, but to reward performance and to allow an increase in fees if actual availability was above 90%. Altera, on the other hand, argued that the worked examples should be followed and clearly demonstrated the intention of the parties. They argued that there was no reason why you couldn't set a target availability at one level, but reward performance at a lower one. The court sided with Altera and concluded that the worked examples should not be disregarded on the following basis. The court concluded that the worked examples formed a part of an appendix to which the front end specifically referred, and that they could not simply be regarded as optional extras. The judge explained that the worked examples formed an integral term of the contract, which explained how any adjustment should be calculated. The judge also highlighted previous case law in which it was noted that, in the context of lengthy contracts, illustrations or examples may actually deserve particular attention as something to which the parties particularly turn their minds. The judge commented that the court could only disregard the express wording of the contract if it was clear that something had gone wrong. In this case, he felt it was possible, but it was by no means clear. The judge did in fact concede that the outcome of the extra steps made less commercial sense, but whilst the sum that resulted may have been commercially unreasonable, it certainly wasn't absurd. The fact that the contract contained not one but two worked examples, both of which featured extra steps not included in the narrative wording, was also deemed to be important. The judge appeared to have thought it was unlikely that both examples would contain the same mistake. It's worth noting that the agreement does not appear to contain wording saying that the worked examples were, for example, merely illustrative, but even if it had, it would still beg the question as to why the parties included them. Why would you bother to include complex worked examples if the intention was for them simply to be disregarded? So it's not clear that the result would have been any different if this type of wording had been included. So that's the facts of the case, and now on to practice points. Generally, our view is that the inclusion of worked examples in contracts are a good thing. The problem with formulas is they often look fine in the abstract, and it's only when you run some figures through them that commercial implications become clear. Worked examples also serve to provide helpful clarity as to how any narrative formula would actually be applied in real-life examples. That said, when you do look to use worked examples, in order to avoid the kinds of problems that seem to have arisen in this case, you may want to do the following. Firstly, make sure that there's no discrepancy between the operative wording in the main agreement and the worked examples. Or if there is going to be, explain why it's there. For example, state clearly that the worked examples are intended to provide more detail. Secondly, consider including a range of differing scenarios, especially where the eventual output of a formula can vary considerably depending on the inputs. This will also help stress test the outcomes of the formula against the party's overall intentions. Finally, and most importantly of all, make sure that any worked examples are front and center of the negotiating process, even if they're destined for a schedule of the agreement. Do not treat them as matters of mere detail that are somehow beneath the attention of the principal commercial negotiators. Thank you very much for joining us, and if you do have any questions, please do feel free to get in touch.